REG Area I also tests the legal and professional duties of CPAs. These questions usually ask who regulates the CPA, what duty was owed, whether confidential information may be disclosed, whether privilege applies, and who may have a claim against the CPA. Section 1. What this topic tests. When you're tackling a legal duty scenario on the exam, you need to systematically break down the facts. These scenarios aren't just random rules. They require a highly structured analytical process. First off, ask yourself who has the authority here, like who actually regulates the CPA in this specific instance. Next, consider what professional duty applies to the situation, and did the CPA's actions constitute misconduct or a breach of that duty? Then you evaluate the parties involved. Was this duty owed directly to the client, or is a third party making a claim? If information was shared, determine if that information was confidential. And even if it was confidential, does a specific legal privilege protect it from being disclosed in court? Finally, what consequence follows? Determine whether the outcome is a loss of a license, a civil lawsuit, or a specific penalty. Mastering this checklist is exactly how you navigate the multiple choice questions in this area. Section 2. Licensing and disciplinary systems. So there's a really clear line drawn between state and federal authority when it comes to your right to practice. State boards of accountancy regulate the CPA profession within their individual states. They set the education and exam requirements, establish the rules of professional conduct, and most importantly, state boards hold the absolute sole power to suspend or revoke a CPA license. The AICPA cannot revoke your license. NASBA cannot revoke it. Only the specific state board that issued the license has that power. On the flip side, we have IRS practice rules, like those found in Circular 230. The IRS can absolutely discipline a practitioner for misconduct. They can suspend or disbar you from practicing before the IRS if you're incompetent, disreputable, or commit tax fraud. But here's the key takeaway. The IRS cannot remove your state-issued CPA license. Losing your IRS practice rights and losing your CPA license are two completely separate disciplinary systems. Section 3. Common law duties to clients. When a client hires a CPA, direct legal obligations are created under common law. At its core, you must exercise due care and competence. That just means performing at the level of an ordinary, reasonable, and prudent CPA under similar circumstances. On top of this general standard of care, CPAs have strict contractual duties defined by their engagement letter. If a CPA fails to meet these professional standards of care or fails to fulfill the exact terms of the executed contract, well, that failure constitutes negligence and a breach of duty. Essentially, you promised to perform at a specific standard, and the actual performance fell short. Now, if a client wants to successfully sue a CPA for negligence, they can't simply point out that the CPA made a mistake. They actually have to systematically prove 4 elements. Step 1 is identifying the duty owed. Did the CPA owe a duty of due care to this specific client? Step 2 requires establishing a breach of that duty. Did the CPA fail to act as a reasonably prudent professional? Step 3 involves proving reliance and causation. The client must demonstrate that they actually relied on the CPA's flawed work and that the error was the direct proximate cause of their financial loss. Step 4 is determining actual damages. This requires the client to quantify their financial harm. If there are no actual damages, or if the error was completely immaterial and didn't change the client's decisions, the legal claim completely falls apart. Section 4. Liability to third parties. The identity and reliance of a third party strictly dictate whether they can successfully make a claim against a CPA. For simple, ordinary negligence, CPAs are generally only liable to their client and to specific third parties that the CPA knows will rely on the work. For example, if you know an audit is being prepared specifically for a local bank to secure a loan, that bank is a foreseen, known user. But if a random, unforeseen trade creditor relies on those same financials and loses money, they usually cannot sue the CPA for simple negligence because the CPA owed no direct duty to them. Now, a claim of fraud is a different story. Fraud involves an intentional misrepresentation of a material fact, or gross negligence that acts as constructive fraud. Because it involves intentional deceit or reckless disregard for the truth, the liability net gets cast way wider. Under those circumstances, a CPA can be held liable to a much broader group of third parties, including completely unforeseen investors and creditors. The law heavily penalizes deceit, which strips away that foreseen user protection entirely. Section 5. Confidentiality. Confidentiality is a broad, professional, and ethical standard regarding client information. The general rule is straightforward. CPAs must protect client information and cannot disclose it without the direct, specific consent of the client. This applies broadly to tax data and non-tax personal information shared during the engagement. However, there are strictly defined exceptions. You do not need client consent if you're complying with a valid, enforceable court subpoena. Consent is also not required to respond to a government regulation or to participate in an authorized professional peer review or a state board disciplinary inquiry. Keep in mind, this standard applies to private information. There is a very distinct difference between sensitive client data and information that is already readily available to the general public.
Section 6. Privileged Communications.
We really need to draw a sharp line between confidentiality and privilege. They're related, but definitely not the same thing. Confidentiality is your broad professional and ethical duty not to voluntarily disclose client matters. Privilege, on the other hand, is a specific legal protection. It allows the CPA or the client to legally refuse to disclose that information when compelled in a formal legal proceeding, like a court case. There is no general overarching federal accountant-client privilege that mirrors attorney-client privilege. So, just because information is held confidentially as a matter of professional ethics, it does not automatically mean it's protected by a legal privilege from a federal subpoena. There is, however, a specific federal carve-out under Internal Revenue Code Section 7525. This section grants a limited privilege for tax advice communications between a federally authorized tax practitioner and their client. But you must pay close attention to the strict boundaries of this carve-out. It applies strictly to civil, non-criminal federal tax matters before the IRS or in federal court. It offers absolutely zero protection in criminal tax matters. It also doesn't generally apply to state court proceedings or private civil lawsuits. If an initially civil tax matter turns criminal, the Section 7525 privilege vanishes immediately, and the CPA can be legally compelled to testify against their client regarding those communications.
Section 7. Privacy Obligations. Alongside confidentiality and privilege, CPAs maintain specific privacy obligations, particularly regarding how tax data is handled. At a high level, privacy obligations dictate that a CPA must be a responsible steward of the sensitive data they collect. This means protecting client information from unauthorized access, securely and responsibly handling all tax-related data, and ensuring that any disclosure of this data happens strictly when expressly permitted by the client or when legally required. It operates as an ongoing operational duty that runs right alongside the ethical duty of confidentiality.
Section 8. Applying the concepts. Let's apply these foundational rules directly to a couple of exam-style scenarios. In our first scenario, CPA Baker decides to expedite a loan application by sending client Carter's tax returns directly to a local bank. But Baker never actually got Carter's permission to do so. What consequence follows? Well, by doing this, Baker committed an unauthorized disclosure. Even if the intent was just to be helpful, this directly violates the core framework we discussed. It's a clear breach of the professional duty of confidentiality, bypassing the explicit client consent requirement. As a result, Baker could face formal discipline from the state board and potential civil liability and a lawsuit from Carter. In our second scenario, a third-party vendor claims they relied on financial statements audited by CPA Davis, and as a result, the vendor lost money. The facts tell us that Davis never knew this vendor existed, and the vendor was not planned or intended user of the audit. Can this unknown vendor successfully sue Davis for ordinary negligence? The answer is no. An unforeseen third party cannot succeed on a simple negligence claim because the required element of duty is totally missing from our liability framework. Davis owed a duty to the client and to foreseen users, not to every unforeseen vendor out in the marketplace. To hold Davis liable, that unknown vendor would have to clear a much higher bar and prove actual fraud or gross negligence.
Section 9. Common Exam Traps.
Let's wrap up by highlighting the specific distractors that frequently trick candidates on the exam. First, never choose an answer that suggests the AICPA or NASBA revokes a CPA license. Remember, only state boards possess that authority. Make sure you don't confuse state board professional discipline with IRS practice discipline because they are completely distinct systems. Also, watch out for questions that assume any third party can sue for simple negligence. Always look for that known or foreseen user limitation. Never treat confidentiality and legal privilege as identical concepts. Pay very close attention to whether a tax matter is civil or criminal before deciding if the Section 7525 privilege applies. And finally, in professional liability questions, do not assume a claim is successful just because the CPA made an error. You have to systematically confirm the presence of a duty, breach, reliance, causation, and actual damages. CPA legal duty questions become easier when you identify who regulates the CPA, who the duty is owed to, whether the issue is licensing, discipline, liability, confidentiality, privacy, or privilege, what consequence follows.